Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, the USPTO's 2019 Patent Eligibility Guidance, 2 months in, Sea Change or Business Methods as usual. I'm Anthony Tridico, and I'll be your moderator today, and it's my pleasure to welcome our speakers, Adriana Berge and John Mulcahy. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. There's an interactive webinar. Just click on the red Q&A button at the lower center of the webcast interface and type your questions into the Q&A window, then click Submit. The questions will be answered today, if we have time, during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will be automatically advanced throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. I'll now turn it over to Adriana and John to begin our presentation, the USPTO's 2019 Patent Eligibility Guidance. Welcome, Adriana and John. The floor is yours.
Thank you, Anthony. Welcome, and thank you for joining us on the webinar today. We have an action-packed agenda in this rapidly evolving area of subject matter eligibility. We will first discuss the revised guidance, the 2019 eligibility guidance. Next, we'll discuss some frequently asked questions and go over the new USPTO examples, and those are examples 37 to 42. Next, we'll round out our discussion by examining what's been happening 2 months in, what type of rejections the office has been giving, and what type of responses applicants have been filing. And finally, we'll take a look at the PTAB. How has the PTAB been addressing the 2019 guidance? As a programming note, we've included a lot of slides, and likely some we may not be able to go over today. However, we wanted to provide them to you and for your reference. With that, I will turn it over to John to start the discussion by examining the 2019 revised patent eligibility guidance itself. John?
Thanks, Adriana. So on January 7th of 2019, the USPTO issued their new 2019 Patent Eligibility Guidance. One item to note is that this guidance became effective the exact same day that it was issued. So the same day it was published to practitioners, it was effective, and the USPTO and examiners were obligated to follow it going forward. So under the old Alice Mayo test, it was a 3-step test. So under step 1, we ask whether the claim falls within a statutory category. And then under step 2A, we ask, is the claim directed to a judicial exception, such as a law of nature, a natural phenomena, or an abstract idea? If the answer to that question is yes, under step 2B, we then ask, does the claim recite significantly more than that judicial exception? If the answer to step 2B is no, then the claim is ineligible under Section 101. So the Alice Mayo test, is a simple 3-part test, but of course the devil is in the details. In particular, under step 2A, examiners were required to determine whether the claimed concept was similar to concepts identified as being abstract in prior Supreme Court or Federal Circuit precedent. And since Alice, there have been 70 decisions by the Federal Circuit or the Supreme Court and counting. And so what was happening was that examiners were required to compare the claims of your application to an ever-growing library of Federal Circuit decisions. And as the USPTO recognized in this new guidance, this had just become impractical. In practice, examiners weren't comparing the claims of your application to the claims of these prior decisions, the claims that issue in these prior decisions. What they were doing was comparing the claims of the application to a one-sentence summary of what the court found to be abstract in those cases. And so those one-sentence summaries were sucking in, if you will, more claims than they should have been, more subject matter than they should have been, and rejecting them under 35 U.S.C. 101. And so what the office did under the 2019 guidance was to try to improve consistency and predictability, allow examiners a better chance to get it right. What was happening in the PTO was that some examiners, and the business method arguments in particular, having been kind of raised on one-on-one rejections, were making them more and more cases, in contrast to other examiners outside of those areas who were making fewer one-on-one rejections. So you had a disparity depending on where your application was being examined, even for similar subject matter. And one of the things practitioners try to do is to steer applications clear of these arguments that were getting a lot of one-on-one rejections. And there's art to that navigation as well. So what do they say in the 2019 PEG? So what they basically did was try to break up Alice Step 2A into these two prongs called prong 1 and prong 2. So under prong 1 of the revised Step 2A, we ask, does the claim recite an abstract idea, a law of nature, or natural phenomena? And here it's important to note that under prong 1, we're not comparing the claims to those 70 the 70 precedents from the Federal Circuit. What they're doing is they're comparing, or they're looking at a very short list of abstract ideas. We'll go over that list in a minute. But that's prong 1. And so if the answer under prong 1 is no, the claim does not recite an abstract idea, then there's no one-on-one rejection. You can move on to address 102 and 103. However, if the answer under prong 1 is yes, we move on to prong 2 and then ask under prong 2, does the claim recite additional elements that integrate the judicial exception into a practical application? Under prong 2, if that answer is yes, then again, there's no one-on-one rejection. If there is a practical application recited, no one-on-one rejection, we can move on again to 102 and 103 issues. If the answer under prong 2, however, is no, the claim does not recite a practical application, we move on to Alice Step 2B and ask whether there is something significantly more in the claim that brings it out from under the one-on-one rejection. So as I mentioned under prong 1, does the claim recite a judicial exception? We're not comparing the claim to those 70 cases anymore. We're comparing the claim basically to this list. We're asking whether it recites a mathematical concept, whether it recites a method for organizing human activities such as fundamental economic principles or practices. We're asking whether it recites a mental process or concepts capable of being performed in the human mind.
Hey, John, can I just interject? Oh, sorry. Can I just interject one thing here? I'm just going to go back to that last slide where you were talking about the abstract ideas and the different categories that the abstract ideas could fall into. I would also note that the 2019 guidance did not change the type of claim limitations that are considered law of nature or natural phenomenon. I know that there's been a lot of questions, and I saw on the comments on the 2019 guidance that they wanted more clarification. But, here we haven't changed anything with respect to the law of nature or natural phenomenon. So, those cases out there, myriad, isolated DNA, cloned farm animals, all those still, those natural things that occur still, falls within a judicial exception. So I just wanted to briefly point that out.
Thanks, Adriana. And then just going forward to looking at prong 2. Under prong 2, we're asking, does the claim integrate this abstract idea into a practical application? We're asking whether the claim applies, relies on, or uses the judicial exception in a manner that imposes a meaningful limit on the judicial exception, such as the claim is more than a mere drafting effort designed to monopolize the judicial exception. And that's the language that they used in the 2019 PEG, and that's one of the things we'll address in the examples going forward. So as I mentioned, under prong 2, looking at whether it's integrated in a practical application, here examiners must give way to all additional elements. And so in the past, examiners were dismissing additional elements that were well understood, routine, and conventional. And so under the new guidance, that question is considered only in Alice Step 2B, where we ask whether the claim provides an inventive concept. Under prong 2 of Step 2A, we're not asking whether these additional elements are well understood, routine, and conventional. We're just asking whether they provide a practical application. And as we'll see as we go through the examples, there are subject matter now that the office is saying should not be rejected under 101 that in the past would have been rejected under 101. And one of the big reasons is this aspect of prong 2, where even if the additional elements are well understood, routine, and conventional, they can still integrate the abstract idea into a practical application and get you out from under a 101 rejection. And so under the 2019 guidance, we have now a 4-part test that replaces the 3-part test of Alice. But it's hoped, and there's some evidence that this is the case, that this 4-part test will now prove easier for examiners to apply in a consistent manner. And so with that, I'll hand it back over to Adriana.
Thanks, John. So after going through this guidance, I bet you there are some questions out there. So why don't we just take a look at some frequently asked questions that we received here at the firm, as well as there is a frequently asked questions that the USPTO has set up, which is a document on their subject matter eligibility website. So here, one of the first questions that I had at least to begin with, and John answered it very, very early on, was when is this effective? When is the comment period? And it turns out, as we discussed earlier, with the publication of this guidance, it became effective. So January 7th, 2019. Just last week, on Friday, March 8th, the comment period closed. And after looking at the comments that were submitted earlier last week, all I really saw was a number of individuals that had submitted comments on the guidance. But towards the tail end of the week, we got a number of associations submitting comments on the 2019 guidance, namely IPO, AIPLA, the ABA, the IP section, LES, and a couple of different corporations. Next up, one of the other questions that I've heard a lot about is, now we have this guidance, examiners are going to be trained on this, right? Yes, of course. As with any complex, rapidly evolving areas of law, the USPTO often gives supplemental training to its over 8,500 examiners. This is really to ensure that everybody has an understanding of the issues, the ever-evolving case law, and how examination should be conducted. The USPTO conducted additional training on the guidance, continues to update its materials reflective of the current case law, and what we've provided here under the training materials are 2 PowerPoint presentations. One of them is the advanced module, and the second one is the intro. In the advanced module, there's over 150 slides explaining the 101 analysis, how it needs to be conducted, what examiners should be looking at. And so I would encourage you, if you have additional questions, if you're wondering how the how the Patent Office is characterizing certain aspects of these different prongs, whether it's Step A, Prong 1, 2, Step B, really that advanced module provides a lot of guidance and a lot of insight too. We have also fielded a lot of questions as to whether the 2019 guidance changes the subject matter eligibility framework. And it doesn't, no. And quite frankly, it can't, because the USPTO administers the law where the legislative branch makes the law and the judicial branch really evaluates it. So that's not really in the Patent Office's wheelhouse to actually change the overall framework. But what's really nice is that on the USPTO's website, they continue to update their materials. As John mentioned earlier on, there's 70-plus relevant decisions on subject matter eligibility that just keeps growing. Well, the Patent Office continues to update its subject matter eligibility chart which is like a spreadsheet of all those decisions, where they were from, what claims were challenged, which ones were found eligible, which ones were ineligible, and it's a great resource. And as a practice tip, this is where I tend to turn to look to a case to analogize to as I'm responding to 101 rejections. Now, what if you have an office action with a 101 rejection under the old guidance? What should you do? Well, here I think this is a great opportunity for you as the applicant to set the tone for how you believe the claims should be analyzed under the new guidance. As detailed in this slide, it's a great opportunity. What we've put here in the slide is really how the examiner is going to take a look at, that next office action and how they're going to proceed. But sitting from the stakeholder perspective or the applicant's perspective, you if you already have an outstanding 101 rejection, you get the opportunity to, go through the analysis yourself and how you want the claims to be analyzed. I will point out that, in each of these the first three bullet points, it kind of goes through what happens if, if the claim does not recite a judicial exception. Well, you don't have to go through the 101 analysis, yippee, right? But really the take-home message on this slide is that last bullet point, where if the claim remains ineligible under the new guidance, the rejection can be made final if the basic thrust of that rejection remains the same. Otherwise, the office can't make the rejection final. And so, I think that's important to keep in mind depending where you are in prosecution. Another question that we've received with the publication of the guidance is, if you're on appeal and you have a 101 rejection, does the office have to reopen prosecution to consider the claims under the new guidance, or can it be addressed somewhere else? You may have an outstanding examiner's answer pending. You may have a reply brief that's still outstanding. And here, really, the Technology Center has discretion as to whether to reopen, designate a new ground of rejection. And, here my practice point is really, I call the examiner, discuss the issue, draw attention to the application and figure out what the best option going forward would be. I would also consider, where are you in the appeal process? Again, do you have an outstanding examiner's answer? You may see in the examiner's answer a new ground of a rejection or a revised rejection as well. Next up, I'll turn it back over to John to go over new examples that the USPTO put out with the guidance, examples 37 to 42. John?
Thanks, Adriana. So as Adriana mentioned, there's these new examples. This is one of the most powerful tools that we have now for arguing cases. If you haven't looked at them yet, I commend them to you to read in detail. We'll go over them, a few of them here today, but there's a lot more detail in the examples themselves and the training materials the USPTO has put out regarding those examples. So they're available at this link given on slide 21. So there are 6 examples. Some have a few claims in each example, and one of the things that we've done here in these slides is reordered the claims. So, for example, example 37 has 3 claims, and if you look at the claims, Claim 1 is actually an amendment to Claim 3, and Claim 2 is an amendment to Claim 1. And so what we've done here is reordered them to kind of present them as you may have gone through them during an oral prosecution, where you're adding recitations to the claims in order to try to overcome the 101 rejection. And we think this is a slightly more educational way to present them. So one of the things to notice about these examples is that they're all very similar in that they're all method claims. There's no apparatus claims in these new examples. One other thing you'll notice is that each one of these claims passes step 1 with flying colors, and that's pretty typical. It's rare that you have a 101 rejection where you're not even reciting one of the category or statutory categories of subject matter, process, machine, apparatus, etc. One other thing that you'll notice is that Step 2B, Alice Step 2B, where you're looking for something significantly more, never saves these examples. So if you are not patent eligible by prong 2 of Step 2A, none of these examples is going to turn the corner at Step 2B. There are, of course, prior cases you could cite for that proposition and prior examples, but these examples here, if you come out of Step 2A ineligible, you're going to remain ineligible under Step 2B. And so without further ado, we'll go in and start with Claim 3 of Example 37. So Claim 3 of Example 37 is directed to a method for ranking icons of a computer system, and it has 2 steps, a determining step and a ranking step. And of course, this is a process, and as I mentioned, all these claims will pass Step 1, and this one does as well. Moving on to Step 2A, we ask whether the claim is directed to a judicial exception. Under prong 1, we're asking whether the claim recites a judicial exception. And here the USPTO says that yes, this claim does recite a judicial exception. So we have a determining step where we're determining the amount of use of an icon over a predetermined period of time, and then we have a ranking step where we're ranking the icons based on the determined amount of use. And what the PTO says about this claim is that each one of these steps could be performed as a mental process. There's nothing a computer for in order to determine amount of use or to rank things in order. And so just because you recite that these steps are done by a processor doesn't save the claim from reciting a judicial exception. So moving on to prong 2 of Step 2A, we're asking whether the claim is, the abstract idea now is integrated into a practical application. And here, the USPTO answers this question in the negative. We're just reciting, again, just a generic processor, and here the mere recitation of a generic processor, and this is a theme throughout these claims, if all you're doing is reciting a generic piece of computer equipment, that's not going to save you from a one-on-one rejection, just as it didn't save you under the old guidance. And then, as I mentioned, moving on to Step 2B, asking whether the claim provides an inventive concept. And as I mentioned, if you're patent ineligible under prong 2 of Step 2A, Step 2B is not going to save you. The processor didn't provide a practical application, and it also does not provide something significantly more. And so the final conclusion the PTO gives for this claim 3 of Example 37 is that the claim is ineligible. And Adrienne, if you want to discuss the rejection of the sample rejection.
Sure, no problem, John. So the USPTO in its guidance and in the frequently asked questions and in the examples that they provided, they also gave us a sample rejection, and that was for example 37, claim 3, the one that John just went over. And what we thought was instructive here was just to take a look at, what the sample rejection looks like, what you should be seeing from examiners now under the new guidance, and how they should be laying out their arguments. So here we have on the slide, this is typically, what you see for a rejection. Claim 3 is rejected under 101. Giving basically a high-level summary. And then next up, in each of these 3 boxes, we see the examiner going through the analysis. So the first box is Step 2A, prong 1. This covers a judicial exception. It's a mental process. It falls under the abstract idea. The middle box or paragraph, we have Step 2A, prong 2. Again, when we look and see if this has been integrated into an application, office says no, it hasn't been. Again, just using the additional element of the processor, it doesn't get us to that point where we've integrated it into a practical application. We haven't said anything as whether it's using this information to do some type of improvement or benefit. And then the last paragraph here, it goes through that Step 2B analysis. And what we'll discuss a little later on under the 2 months in, you'll get to see all the different flavors the examiner examiners have come up with, when they are giving us a 101 rejection and what it looks like under different technology centers as well. So I will turn it back over to John to go through some additional examples.
Thanks. So as I mentioned, Claim 1 of Example 37 is actually an amendment to Claim 2. And so we've added these underlying recitations to Claim 3. So now we're talking about a method of rearranging icons in a graphical user interface of a computer system. We've added a receiving step. We're receiving user selection, and then we're determining the amount of use of each icon as before, and then we're automatically moving the most used icons to a position on the GUI closest to the start icon. And so looking again at Step 2A, Prong 1, asking whether this claim recites judicial exception. Here, the answer is still yes. But for the recitation that these steps are done by a processor, the claim would still encompass mental calculations. And here, I think the analogy is something you could do with pen and paper. Moving on now to Prong 2, however, asking whether the claim integrates this abstract idea into a practical application. Here, the USPTO answers yes. So this amended claim, or we're talking about receiving an input from the graphical user interface and then automatically moving the most used icons. These are now integrating this abstract idea into a practical application. And so you'll notice that what we've added here, a receiving step, receiving input and then automatically moving things around a computer screen. Under prior guidance, a lot of examiners would have dismissed those as being well understood, routine, and conventional. But here, the USPTO management is saying to examiners, under Prong 2 of Step 2A, you need to consider these. Even if they're well understood, routine, and conventional, you still need to ask whether they nevertheless integrate the abstract idea into a practical application, even if that application is old and perhaps obvious. That's not what we're asking under Step 2A. We're just asking whether there's a practical application. If there is, and you think that it's old or obvious, you can address those issues under 102 and 103. But we've gone over the 101 hurdle, and so that's a welcome change, I believe, for a lot of applicants. So under since we're eligible at Step 2A, we don't even have to answer the question regarding Step 2B. And so I'll move on to Claim 2 of Example 37. As I mentioned, Claim 2 is a further amendment to Claim 1. And here we add a recitation where we're determining the amount of use of each icon using a processor that tracks how much memory has been allocated to each application. And here, interestingly, looking at Step 2A, Prong 1, asking whether this claim recites judicial exception, here the USPTO answers no. Because the determining step now requires a processor that tracks how much memory is being allocated to each application, the USPTO has indicated that the determining step cannot be practically applied in the human mind. And so now the claim is eligible because it does not even recite judicial exception. We exit Step 2A at Prong 1. And because that's the case, we don't have to answer the question regarding Prong 2 or Step 2B. And so here again, this is, I believe, a welcome example. Could be very useful to applicants going forward in trying to get out from under a 101 rejection. I'm going to move on, skip over examples 38 and 39 and move to example 40, Claim 2. And Claim 2 of example 40 is directed to the adaptive monitoring network traffic data, where we have a network appliance connected between two computing devices in a network. We're collecting data regarding network delay, packet loss, or jitter, and then we're comparing the collected data to a predefined threshold. Here under step 2A, prong 1, asking whether this claim recites judicial exception. Here the USPTO answers yes. We have a comparing step, but just comparing one number to a threshold is something that could be practically performed in human mind. And the recitation that this is done by network appliance, a generic network appliance, doesn't save the claim. And so therefore the claim recites or encompasses a mental process. Here we're asking whether under prong 2 now, whether this abstract idea is nevertheless integrated into a practical application. And here the USPTO answers no. So we have a collecting step that arguably couldn't be done without some technology to collect all this data. But the mere collection of data is said to be insignificant extra solution activity. And the fact that a network appliance is doing it and the comparison step does not save it, does not save this claim. And so therefore this claim is directed to an abstract idea and ineligible. Looking under step 2B, asking whether this claim provides an inventive concept. As I mentioned before, where you fail under step 2A, in particular prong 2, you're not reciting a practical application. You're also not reciting significantly more. And so this claim is finally determined to be ineligible. Looking then to claim 1 of example 40, here we're reciting that it's a method for adaptive monitoring of traffic data through a network appliance. We're collecting the same data again and comparing it to the same threshold. But then if the collected traffic data is greater than the predefined threshold, now we're collecting additional traffic data relating to the network traffic. So looking again under step 2A, prong 1, asking whether the claim recites a judicial exception. Here again, the answer the USPTO provides is yes. So we still have just this generic network appliance collecting the data and comparing the collected data to a threshold. And the additional collecting step does not save it from reciting a judicial exception. But looking now under prong 2, asking whether the claim integrates the abstract idea into a practical application, here the USPTO says that the answer is yes. Although each of the collecting steps may be viewed individually as mere pre- or post-solution activity, the claim as a whole is directed to an improvement in collecting traffic data. And this is a very interesting example because here we have a generic network appliance and under in claim 2 we saw that this just a mere collection of data in comparison to the threshold was not enough to save the claim or recite a practical application. But here we have another collection step added to the claim, and basically because it's a conditional step where you're only collecting this additional traffic data when the previous data is greater than a predefined threshold. Now the PTO says, well, this now is enough to recite a practical application. And so this is a great example to have for those types of applications that are where the improvement is directed to the software that is being run on a generic computer. And so a very helpful example going forward for those types of applications when you need to argue with the examiner, whether or not your software-based improvement can be a practical application or over and above what could be considered, what the examiner would have previously identified as an abstract idea. And so moving on now to the final example from the USPTO, example 42. There's 2 claims here as well. Under Claim 2, where we have example 42, we have a method where you are storing information about a patient's condition, you're providing access to the users so that a number of different users can update this information, and then we're storing the updated information. So under prong 1, we ask whether this recites a judicial exception. Here, the USPTO says that the answer is yes. It's just reciting a method for organizing human interaction. We have the storing step, we're updating records. This can all be done with pen and paper, and just because the claim recites a content server and non-transitory storage devices, that does not save the claim from reciting a judicial exception. So under prong 2, now we ask whether those storage devices and content server can nevertheless integrate the claim into a practical application. But here, the USPTO says that the answer is no. They're just tools used to automate an existing medical records update process. And simply implementing an abstract idea using a generic computer is not enough to recite a practical application of the abstract idea. Moving on to claim 1 of example 42, however, we've added a number of steps. And in particular, we've added some steps that talk about converting a non-standardized information into a standardized format, and then providing these updates in real time through a graphical user interface, as indicated by the underlying text. So under prong 1, we're asking whether this recites judicial exception. Here, the USPTO says that the answer is still yes. It still recites a method of organizing human activity, and these rather generic recitations don't save it under prong 1 from reciting a judicial exception. Under prong 2, however, the USPTO points to a number of these added recitations and now says that these added recitations now integrate the abstract idea into a practical application. So this is a very interesting example as well, and very useful going forward for presenting your arguments to the examiner and to getting over a one-on-one rejection. Here we have a number of recitations talking about storing information in a standardized format, providing remote access to users over a network, converting non-standardized formats to standardized formats. Under most examiners' views prior to this new guidance, these would have all been dismissed as well understood, routine, and conventional. We're just storing information in standardized formats. Well, that's by definition kind of well understood, routine, and conventional. And then converting a non-standardized format to a standardized format. Here again, a well-known step. Here, however, even though these are well understood, routine, and conventional details, they are enough to recite a practical application. So even though perhaps old and obvious, it's enough to get us over the one-on-one hurdle. So this is a great example just to show the examiners that even if the additional elements that you're citing the claim are old, obvious, well understood, routine, conventional even, they can still be enough to get you over the one-on-one hurdle. If they're old and obvious, we could talk about those issues under 102 or 103, but at least we get past that to get to those questions. And with that, I will turn it over to Adriana to talk about the rejections response we've actually been seeing from the PTO 2 months in.
All right. Thanks, John. So what has been happening since January 7th, 2019 in some real applications? What we try to do is we try to get a big picture view. We conducted some searches to see really how often the office as well as the applicants cite to the new guidance. and cite to the new guidance in office actions as well as responses. So we searched on the term at the bottom of the slide there, 2019 Revised Patent Eligibility Guidance, and we conducted the search on March 1st. Again, just to get a slice of time to see, what tech centers are issuing more 101 rejections with the new guidance, and are applicants integrating the new guidance in their responses. And so what you see here in the table format is really how many office actions cite the guidance as well as responses. And this is by no means exhaustive, but what we try to do is just, again, give you a representative slice. I think the other thing to keep in mind is because the guidance went into effect in the beginning of January, there still was probably a lag period by the time that examiners got up to speed on training and really started to implement using the guidance. But nonetheless, when you take a look at this, clearly you see with the red arrow, Tech Center 3600, which is transportation, electronic commerce, construction, agriculture, and licensing, clearly from an office perspective as well as a stakeholder perspective, they have been citing to the guidance constantly, it looks like. And then from the applicant's perspective, up at Tech Center 2100, there we have 176, and 2100 is computer architecture, software, and information security. So again, what we wanted to try to give you was just an idea of, the office as well as applicants and stakeholders integrating this into their practice. We also wanted to see if the office had identified any claims that actually didn't fall within the enumerated groupings of abstract ideas. Early on, John gave you the slide that had those three different, I call them buckets of abstract ideas. In the 2019 guidance, the office said that, there may be instances where an abstract idea doesn't necessarily fit in one of those buckets. And if it doesn't fit in one of those buckets, then the patent office still may give you a 101 rejection. And what they deemed this abstract idea that didn't fit within those buckets, it was called a tentative abstract idea. And if the examiner wanted to give a tentative abstract idea 101 rejection, he needed to kind of go up the hierarchy to ensure that it fell within, this other category. And so again, we wanted to see, well, has the office identified any of those tentative abstract ideas? Because if so, I think that would be very instructive as well as educational to us to have an idea of really what would fall outside of the abstract ideas that they've given us. Again, what does it really mean to be a tentative abstract idea? So what we did is, again, we searched tentative abstract idea. There were 17 documents that pulled up, but interestingly enough, no hits in office actions with this tentative abstract idea. However, from the applicant perspective or the stakeholder perspective, you could see that applicants in some instances were self-identifying as having a claim or subject matter directed to a tentative abstract idea. But in large part of those 17 documents that we looked at, a lot of them were just actually regurgitating the 2019 guidance, how the analysis should flow. You will see there were a couple of instances where, they did self-identify as being a tentative abstract idea, but irrespective of that fact, they argued that under Step 2A, Prong 2, this tentative abstract idea was integrated into a practical application. Again, I think this would be very instructive. Maybe give it another 2 or 3 months to see if the office has come up with subject matter that falls within that tentative abstract idea. Next, I'll turn it over to John to go through some of the stuff that we've been seeing here at the firm.
Certainly. And so just want to go back for a second here. We had a question, why is Mechanical Group 3600, the group citing the new guidance in the most office actions? And one thing you need to know about 3600 is that it's a Mechanical Group, but it is a kind of a catch-all group. I was actually an examiner in 3600 back in the late 90s, early 2000s. And in that group, I examined such diverse things as electronic medical devices, ultrasound, endoscopes, exercise devices, mechanical items, also flight simulators, games, etc. So there's a lot of things in 3600, and one of the things that is driving this number is 3600 is where a lot of the business method type applications are examined. And so that's the reason why you see most of the activity being concentrated in 3600. But moving forward, what we did was we took a look at the off section. We got in the 5-week period since the examiner the guidance really took effect at the USPTO from January 28th to March 3rd, and then we compared it to a similar 5-week period back in October through November, and I chose that period because it was a similar 5-week period with no major holidays. And it was also, past the prior, like the Berkheimer guidance and things like that. So we're kind of comparing apples to apples in these 2 5-week periods. We looked at first the non-final rejections, and we saw that before under the old guidance, we got 101 rejection and about 22% of non-final actions. Up under the new guidance, about 18%. So a small difference there, about 20% or so. Looking at final off actions, however, under the old guidance, we were getting 101 rejections in about 30% of these final rejections. Under the new guidance, less than half that, so 13.5%. And so overall, looking at all the actions we received in these 2 periods with 101 rejections, it was about a quarter of the cases before the guidance, only 16% after the guidance. So we're seeing basically 1/3 fewer 101 rejections. And so I know people are kind of hopeful that we'll see even fewer than that going forward, but at least the trend is pointing in the right direction, and the guidance is having the effect that it was desired by the USPTO management. With that, I'll turn it back over to Adriana.
So we're going to shift gears slightly a bit and look at, how to respond to a 101 rejection that utilizes the 2019 PEG guidance. And, I think one of the first considerations that you take a look at is really have an understanding of what the rejection is based on. Take a look and try to attack, prongs 1 and 2. Prong 1, does this fall under a judicial exception? And prong 2, have you integrated into a practical application? And I have an interesting story for prong 1. I recently submitted a response back in the beginning, I think it was the beginning of February, where we had a case that went to notice of allowance and then it got pulled and we received a 101 rejection. After a series of basically the office maintaining the 101 rejection, I submitted a response using the 2019 guidance and went through the whole analysis. And lo and behold, I would say maybe a week or 2 ago, we got a notice of allowance. And in the notice of allowance, the examiner, even though the office, pulled my notice of allowance and issued us 101 rejections and multiple 101 rejections in multiple office actions, they came back to find that under prong 1, we no longer recited a judicial exception. So even though I kind of think prong 1 is a little straightforward as to whether you fall under that judicial exception or not, it's still an opportunity to argue, and I wouldn't let it go even, particularly, again, under the revised guidance, under the buckets now, the 3 buckets of abstract ideas. I think that looking at the guidance and what they define as, for example, mathematical concepts and the algorithms, do you recite actually an equation, or are you more along the lines of discussing how certain parameters are used together to ultimately come up with some integration of those parameters to come up with a different benefit? So I think there's some wiggle room room there to continue to argue under prong one that you may not even fall within an abstract idea. But again, I think those two prongs give you the best chances of getting out of a 101 rejection. Next up, conduct an examiner interview. I'm a huge proponent of conducting examiner interviews, regardless of whether you've got a 101 or not. I think, to talk to the examiner, find out where they are, what the problems are, what the issues are. Sometimes it's hard to decipher. When they put pen to paper, when they give you your office action, you may be reading it in a certain way where the examiner, has a different connotation of a phrase, or how they're looking at the prior art, or in this case, how they're evaluating your claims under 101. And I think it's best to have that understanding, and it gives you, again, another opportunity to go back and find out where you can argue. As John went through the new examples 37 to 42, and as he mentioned, there are some good examples that you can use to analogize to potential claims that you have pending under 101. Any claim that has been considered patent eligible under the old guidance should also be considered patent eligible under this guidance. And on the PTO website, again, they have a ton of examples, and there's an opportunity to analogize. Always helpful. And again, this next bullet point, argue integration into a practical application. We've talked about that. Again, that's step 2A, prong 2. We have a couple more slides after this that talk about, that integration into a practical application, and what we can pull from the case law that shows that there has been an integration. And again, if you can analogize to a case or to one of the examples, particularly under that prong 2, I think that's where you get your most mileage. The next bullet point, step B, significantly more. I think we heard John again mention that, in those examples, I don't believe that any of the ineligible claims under step B provided a way to go forward under step B. So I think that significantly more prong under step 2B it's a difficult hurdle, particularly that's where the examiners are given the opportunity to consider conventional and routine elements. And lastly, I think what we've seen from the 101 rejections and being able to overcome them is that, this is highly specific to your claims and your elements, that there really is no rubric that you can put together to overcome a 101 rejection. I really think that, it's highly dependent on the claims, your elements, and what you currently have pending. And I think it's also important to consider, when looking at all of these different ways to tackle the 101 guidance, is that, there's over 8,000 different examiners. They're all going to have a different take, a different interpretation. I think that's, again, why it's important to conduct an examiner interview, find out what they're thinking, how they're interpreting your claims, and typically that is, it gives you some good guidance as to how and where you need to go forward. The other consideration is that, your audience is not only the examiners, but it's also potentially a district court judge, an ITC, the PTAB judges, the Fed Circuit, the Supreme Court. And so it's important to keep those things in mind as you're arguing. And because you are arguing, you're creating, in some respects, some prosecution history estoppel. So again, important to consider. So this next slide really merely highlights under step 2A, that prong 2, examples where the judicial exception was found to be integrated into a practical application. And most of these have come from the case law. For example, I think it's bullet point 2, improvement to other technology or technical field. I think that is an example of the Vanda memo, these methods of treatment where there's a practical application of that natural relationship, and it's just not that recognition of the relationship itself. I think when you scroll down to the transformation or reduction bullet point there, I think that's the classic example of Diamond versus Deere. And so, these really are, again, pulled from the case case law, but ways to take a look at and ways to argue, again, that integration. Here on this next slide, we go through some of the examples where there was no integration into a practical application. Again, these were all taken from the case law, but I think what's really instructive here is the last two bullet points, that you really have to take a look at this combination of elements altogether. In some instances, a single element may do it for you, but in most instances, it's really this combination of elements that were put together in some particular way that may save you from the 101 rejection or overcoming it. Also, again, as a reminder, you need to consider the claim as a whole to determine that integration. Again, these are things to consider as you're going through and as you're drafting your arguments. These next three slides I actually took from the USPTO's Advanced Training Module on 101 that I had referenced earlier on. Here, it highlights this overlap in some instances between Step 2A, that prong 2, and Step 2B considerations. So here, under the Step 2B, the examiner is going to be able to consider those well-understood routine and conventional activities. And so if at all possible, it's really best to get out of 101 under that Step 2A, prong 2. These next two slides, again, I took from the PTO's training materials, go through their examples that are on the website, and indicates, these examples here on this slide were unaffected by the new guidance. And the next slide goes through and indicates examples that were affected, but maybe now, for example, in the left-hand side, examples with claims that are now eligible under that Step 2A, prong 2, and then on the right side, examples where the result is unchanged, but that would require an additional analysis under that Step 2A, prong 2. So the next several slides, what we put together are just different examples from different technology centers of the types of office actions that are coming out using the guidance. You'll see that in some instances, the examiner really is going back to the old guidance and then interspersing or sprinkling in the 2019, prong 1 and prong 2. But here's just an example of from Tech Center 1600, typical, claims 30 to 37 rejected under 101 because they recite a judicial exception. And then this is where you see the examiner citing to the new eligibility guidance. They're going through the steps. And here, it may be a little difficult to see, but what we've highlighted is where the examiner goes through the Step 2A, prong 1, what type of judicial exception it recites, and then prong 2, is it integrated into an application? And then finally here, it looks like this one does not survive, that there was not significantly more under Step 2B. Tech Center 1700, again, this is just a different flavor of the type of rejections that we're seeing. The examiners are trying to integrate those different prongs into the analysis. One that I definitely would like to go through, let's stop and talk about this one, Tech Center 2400. Folks, it does happen. 101 rejections have been withdrawn under the new guidance, and here's an example of one of those where the examiner says that the claim rejections under 101 have been withdrawn because although the limitations still recite an abstract idea, so still Step 2A, prong 1, they're still an abstract idea, but the limitations include additional elements that reflect an improvement in technology. So again, there's that prong 2 integration into a practical application. And it's nice to see that the examiner went on record and provided clarifying comments on why the 101 rejection was withdrawn. And let me just skip ahead to Tech Center 3600 since we talked about this one, and there was a question as to why are we seeing more here? And what's interesting to see in this particular rejection is that the examiner provided essentially a claim chart and identifies which steps of the claim he finds contains under prong one that judicial exception, and in this case a mental process. And so it's nice to have this laid out because now you know exactly which steps the examiner is identifying as being falling within that judicial exception. And here under step 2A, prong 2, the examiner again provides an analysis as well as under step 2B. So I'm going to turn it back over to John to see what's happening at the PTAB.
Thanks, Adriana. So just as there's kind of a disparate treatment of claims under the new guidance by the examiner corps, there's also kind of a disparate treatment at the PTAB. So we've looked at a number of recent decisions that at least cite to the 29 Patent Eligibility Guidance. And this first page here shows a number of cases, all in the business method area. And unfortunately, as you can see by the red, all these claims were ultimately held to be ineligible. And so, the initial message there might be that the 2019 guidance is not going to help you get a business method patent through appeal. However, what you should remember about these cases is that they were all, the claims were finalized months and months ago before the guidance, before even Berkheimer came out. And so the people filing these appeals didn't have the benefit of a lot of the recent guidance, in particular the 2019 guidance, to adjust their claims to get around a one-on-one rejection. So business method applicants don't lose hope. There were two cases kind of outside the business method area that were found eligible under the new guidance. And there's one case which is I recommend reading just for the claims. That is the entirety of Independent Claim 10, talking about a method comprising clicking on information and in response to the clicking, conducting a web search. So that was reversed and remanded for further consideration by the examiner under both the new guidance and also considering a written description rejection. So there was one set of cases that we found in an IPR where the PTAB addressed the 2019 guidance. In this case, the hearing was scheduled for just a week after the guidance came out. The PTAB asked the parties, what should we do about this? And both parties actually said that the guidance doesn't change anything. The petitioner said the claims were ineligible before, they're ineligible under the guidance, and of course the patent owner said they were eligible before and eligible under the guidance now. But what happened in that case was the parties were given extra time to argue the issue during the hearing, and then they were able to submit a 5-page brief to brief the issue. But ultimately the hearing was not postponed and went off on schedule. And with that, I'll turn it back over to Adriana to give us some final thoughts.
Thanks, John. So I think there's a couple things that we need to keep in mind when we're dealing with the guidance and living under it. And, these, what I have here on the slide are direct quotes from the 2019 guidance themselves. And I think it's important to keep in mind that, the guidance is not substantive rulemaking. It's really just been a tool for the office to use to address, the stakeholders' concerns by, the lack of predictability and consistency under 101. I think it's pretty admirable that Director Iancu has, taken on this very difficult issue early in his tenure to try to seek some clarity. But ultimately, the guidance is not substantive law, and I think you need to keep that in the back of your mind. As I mentioned early on, that chart that the office updates pretty consistently on a monthly basis of recent decisions on subject matter eligibility. I think you need to keep that in mind. That's the case law. That's what you need to ground your arguments in. And I think it's also important to point out, again, this is a direct quote, and this is the last bullet point here, is that failure of USPTO personnel to follow the guidance is not in and of itself a proper basis for either appeal or petition. Again, keeping in mind the sheer number of examiners at the Patent Office, there are going to be some that deviate from the guidance, and I think it's important to keep that in your mind. Make sure you're creating a clear record. I think the other thing that we also have to bear in mind is that we just closed the comment period, and that was last Friday. Things may change. As we've already seen, and speaking historically, how many different memos have we already seen, has the PTO already put out? This is going to be an iterative process. And as such, there may be further changes made based on comments the Patent Office has received during this comment period. So I think that's important to keep in mind. The other two things that I think are important to keep in mind is that just because you follow the guidance does not necessarily guarantee that the claims are going to be patent eligible. And we have not seen any court cases where the federal courts have agreed with or have anointed the 2019 guidance as being, instructive. So I think that there's still a lot of unknowns. Again, it's going to be an iterative process, and we may continue to see periodic supplements as we move forward. And, looking at just recently some of the comments that the different organizations have submitted, although they each have a slightly different take on their comments and what they're suggesting to the Patent Office needs to be revised in the guidance, I think the consistent theme, or at least what's been linking them all together, is the need for some legislative action to occur. And I think that's important to also keep in mind. I know that we've been hearing rumblings that members of Congress have been holding meetings to talk about this issue, and it may ultimately only be solved from a legislative perspective. So with that, I think we will turn it back over to Anthony.
Great. Thanks, Andrea. Thanks, John. I have to apologize to all of our listeners. With that webinar so packed with information, we unfortunately don't have time to address any of your questions. I do promise, however, if you left a question, the speakers will reach out directly to you, or please feel free to follow up with any one of us via email or phone call. I'd be happy to answer or try to address any of your questions. Finally, I'll ask the listeners, please take a moment to complete the evaluation survey. We always strive to provide programs of value and continually improve our programs, so we really do appreciate your input, especially on topics of interest or topics you'd like to see in future webinars. That will really help us guide us in planning programs for the future. Finally, thank you for attending today's webcast, the USPTO's 2019 Patent Eligibility Guidance. 2 months in, sea change or business methods as usual. As always, the presentation will be available on demand in the next week. Look out for an email from us with the access link. This concludes today's Finnegan webcast. Thank you very much for participating, and have a good day.